And me being a living person, my name is Improper Punctuation. I don't have a all caps name. So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes. Okay. Thank you for your patience there. We had a little bit of a kerfuffle. So, recalling case number 19S00472, that is the state of Michigan versus Thomas Ulrich Styron the second, you said, and also calling 24W001025, that is the township of Ypsilanti, also versus Thomas Ulrich Styron. So state your name for the record.
So, for the record, my name is Thomas Styron II. It is not the name you have attached to this case is not me. I believe that's a state created entity, Your Honor. Okay. And me being a living person, I don't. My name is Improper Punctuation. I don't have a all caps name nor.
Okay, I'm going to cut you off right there. Okay.
I don't have no contracts with the state of Michigan at all, period. And so I was wondering about personal jurisdiction and subject matter jurisdiction in regards to this.
Okay. And you can continue to wonder about those at the moment. What I am doing, you have a show cause hearing on the matter ending in 472, which is the retail fraud charge. I'm showing a balance.
This hearing captures a common courtroom exchange where the defendant challenges the court's authority before addressing the underlying charge. He argues that the name on the case represents a separate legal entity rather than himself as a living person, questions personal and subject matter jurisdiction, and maintains that he has no contractual relationship with the state of Michigan. Throughout the hearing, he repeatedly asks whether jurisdiction must first be established before the case can proceed.
I'm showing a balance of $210 on that. And then what you are being arraigned on, that is what I am here to explain the charge against you, is a citation issued on April 2nd, 2024 at 9:24 in the evening. That charges that you operated a motor vehicle on North Ford Boulevard at or near Russell Street with no license on your person. Do you comprehend the charge? Okay. So, what you are being charged with is operating a motor vehicle without having a license on your person. So, I'm not asking you if you agree with this. I'm not asking if you have a license. I'm asking if you understand the words coming out of my mouth as far as what this charge is.
The charge is accused of not having a driver's license on my person, correct?
Correct.
Well, from my understanding, I need a driver's license if I'm in commerce. I was traveling home.
Okay.
I wasn't doing business at all. And also from my understanding,
The judge responds by explaining that the purpose of the hearing is limited to addressing the pending matters, reading the charge, confirming that the defendant understands it, and scheduling the next court date. When the defendant raises arguments about traveling versus driving, licensing requirements, and jurisdiction, the judge states that those issues are not being decided at that stage and instructs him that any supporting documentation can be presented during the pre-trial hearing. The court proceeds with the arraignment, enters a standing mute plea, and sets a personal recognizance bond.
And your overstanding is incorrect, sir. But we are not going to get into that for now. You are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
So,
At this time, the court is going to set a pretrial date for you. That will be before Judge Washington.
ma'am, can we prove the jurisdiction first before we go ahead with setting a trial for that entity or a pretrial for that entity? I don't. Yeah.
I hear you. And at this point, you are appearing in front of the court. You have put your name on the record. And yes, we are setting a pretrial date for you.
I did put my name on the record, and my name that I put on the record is not the same name that you have attached to that case.
And you can provide documentation of such at your pretrial date, which is going to.
The exchange highlights the contrast between the defendant's attempt to challenge the court's authority at the outset and the court's focus on following standard criminal procedure. Rather than debating the legal theories raised, the judge keeps the hearing centered on procedural matters, including the charges, scheduling, and bond conditions. The hearing concludes with the defendant continuing to question whether jurisdiction should have been proven first, while the court informs him of his obligation to appear at the scheduled pretrial hearing.
26th.
So the documentation that I have published, recorded in with, excuse me, sorry, the documentation I have published and recorded on the record, on the state of Michigan record, that says what I just told you, that I'm not who you have, that I'm not the name you have attached to that case. That's I need to bring that with me, is what you're saying? It being already recorded and on the state of Michigan records. Is that good enough?
Whatever documentation you have,
Mm-hmm.
bring it with you to your pretrial date. That is what I am telling you, yes. So, and again, that court date, June 26th? Okay. Will be June 26th at 9 a.m. before Judge Washington. The court will enter that you are standing mute to all charges at this time.
So we're just assuming jurisdiction, though, correct?
Yes.
How? From my understanding, that has to be proved before we even proceed with anything else.
You are not correct. The court will also set a personal recognizance bond in this matter. Basically, you are promising to show up for that June 24th court date at 9 a.m. over Zoom before Judge Washington, where you will have your pretrial. Okay, so at this point, your hearings are concluded. You are free to stand up and tell the jail that you are finished.
So I need to be there on the rest